Nobody wrote a judicial opinion better than Oliver Wendell Holmes Jr., not the physician, poet, but the son. And you read his opinions, and they look like masterpieces of Aristotelian logic. Well, it's well established, this is the law, and we also know that is the law, therefore it follows, and this is how the case ought to be resolved. This is brilliant, breathtaking, so elegant, simple, and concise. And yet it was he who famously wrote, "The life of the law is not logic, it is experience."
Now, what do you think he meant by that?
Well, remember, he fought in the Civil War. He was wounded 3 times. 3 times he almost bought the farm. Life experiences are what really forge judicial decisions. And a good, healthy dose of life is necessary. People point to the Warren Court and say, you look at that court and you have a senator from Alabama, a former Ku Klux Klan member, Hugo Black, okay, who became a great liberal. Black brought his experience. He was white, obviously. He brought his life experience to the court. You had 2 governors, including Earl Warren, the great governor of California, elected 3 times in succession. I mean, Jerry Brown has been elected 4 times, but this is in succession. Eisenhower was terrified of him. The last 2 times Earl Warren had been elected, he was the candidate of both parties. That's how popular he was. So here's a guy who knew the rough and tumble world of politics. Here's a guy who, as governor of California, signed the internment laws, brazenly, theatrically boarded the gambling ship, the Rex, in Santa Monica Bay. I mean, he was a showman, but he had a lot of life experience. And I think that's what Holmes was talking about. You dress it up in what looks like logic. It isn't. I mean, one of the biggest water cases of the last 100 years is a complete logical fallacy. That's the so-called Mono Lake case, National Audubon Society versus Superior Court. It hinges on one of the classical logical fallacies, petitio principii. It begs the question. The question is, does the public trust doctrine apply to the waters of a navigable body of water? The way the Supreme Court of California dealt with that, in half a sentence. Unquestionably, the public trust applies to the lands and waters of a navigable body of water such as Mono Lake. Oh, unquestionably. Wait a minute, that's the very question you're supposed to decide. You see? So you dress it all up so that it looks like everything is based on precedent, but what you've really done is, in your heart, you figured out which side ought to win, and then you construct something that gets you there and is hopefully not laughed at, like that opinion is laughed at by me and my students when I explode it for them. Because this is one of the great sainted opinions in environmental law. Ask any environmental lawyer, name me the 5 greatest environmental cases of the last 60 years. The Mono Lake decision, right up there. It's a complete travesty, completely intellectually dishonest, but it's law.
What I'm hearing you say is that law, as you had come to understand it in law school itself, is really about meaning making, and how much meaning can you put on something that doesn't have meaning of its own?
Exactly. Imposing apparent order on what is really entropy, chaos.